Right friends, welcome back to newspaper editorials discussion. Total 4 issues. First one is with regard to pollution, and please recollect what happened around 7-8 months ago. This is death of a fish in Ulsur Lake. Please recollect death of fish in Ulsur Lake. Now the issue is of Bangalore Lake. These two are situated in Bengaluru, and in Ulsur Lake death of a fish occurred in May 2016. What is the reason? The reason is in the water dissolved oxygen levels came down to 1 milligram per liter, and the acceptable limit is 4 milligram per liter. Because of the dissolved oxygen level coming to as low as 1 milligram per liter, because of pollution, several fish died in Ulsur Lake in Bengaluru 8 months ago. And now look at Bangalore Lake. This is also in Bengaluru. Here a fire erupted recently. In the lake, a fire erupted. What is the probable reason? The probable reason is because of the chemical reaction in the sludge. Untreated sludge is giving its way into lake. Because of untreated sludge, this chemical reaction is taking place, and it might have released methane gas in excess. Because of excess methane gas, fire erupted in Bangalore Lake. So Ulsur Lake, Bangalore Lake, what happened? What are the probable reasons? These things please keep in mind. And let us come back to wetlands. What is the meaning of wetlands? There is one convention, that is the Ramsar Convention. At the same time, India gave the rules, wetland protection rules of 2010 were given by the Ministry of Environment, and they are not being implemented properly. That is different story. And what is meant by wetlands? Wetlands are nothing but the bodies, or you can say areas, where water covers the soil, and here water is present either at or near the surface of the soil all the year or for varying periods of time. And here water saturation, the saturation of water in the soil, that finally determines how the soil develops. And another important aspect is it supports both aquatic and terrestrial species. Aquatic species, the species who live in water, terrestrial species who live on dry land. So these two types of species are supported by these wetlands. So this is the meaning of wetlands. And wetlands and Bengaluru, as per this editorial, Bengaluru lost an estimated 79% of water bodies and 80% of its tree cover during the past 40 years. More than 40 years, during the past 40 to 45 years, 79% of water bodies were lost and 80% of its tree cover was lost. And probably this is the same story for any of the city in our country. And what are the reasons? The reasons are basically encroachments of lake beds. Several lakes in Hyderabad have also been disappeared because of encroachments, and sometimes with the support of politicians. Then the second point is catchment areas are also being occupied for commercial exploitation. Catchment areas means the areas where the water flows into lakes or rivers, where the water drains out into these rivers or lakes, that is catchment area. And catchment areas are lost, then water channels are lost. Because of these reasons, pollution in lakes, pollution in rivers is increasing in our country. This is the irony. And severe pollution is caused by sewage, industrial effluents and garbage into the water bodies. Most of the times untreated sewage is let into the water, and one classic example is Ganga river near Varanasi. And then soil scientists, recent times soil scientists found that the higher levels of cadmium when green vegetables are grown by using water from Bengaluru lake in Bengaluru. Scientists found that higher levels of cadmium were present in vegetables, which may cause harm to the human beings. So, this is the story as far as wetlands are considered, not only in Bengaluru, but also in other cities, right. Please look into this picture. Then further, loss of wetlands and other aspects. There was one study by Salim Ali Center for Ornithology and Natural History. As per this study, 38% of wetlands were lost nationally. 38% of wetlands were lost nationally, and in some of the districts only 12% of wetlands survived. And subsequently, Government of India gave rules for conservation and management of wetlands, and they have chosen 115 water bodies in 24 states for protection. And what about world conventions? And for these wetlands, there is one world convention. India is also signatory. Please do not forget, that is Ramsar Convention. Ramsar Convention is named after the city of Ramsar in Iran. And this Ramsar Convention was signed in 1971, and this is for the conservation of sustainable use of wetlands. And second important point is, India is also signatory, and it covers a wide variety of habitats, not only rivers, lakes, lagoons, salt ponds, sewage farms. So, these are all covered by this Ramsar Convention. And next point is, Wetlands Conservation and Management Rules 2010 were given by the Ministry of Environment. These wetlands conservation and management rules were given, and these were framed for the protection of wetlands in 2010, and the rules mainly protect Ramsar wetlands of international importance. Certain wetlands are named in the Ramsar Convention, and these wetlands will be protected by using this wetland conservation and management rules. And the second point is, wetlands situated in ecologically sensitive areas, and at the same time wetlands situation in UNESCO World Heritage Sites are also covered. And please do not forget, India has got around 35 World Heritage Sites, and these will also be covered. If wetlands are lying within World Heritage Sites of UNESCO, they will also be covered under Wetlands Conservation and Management Rules of 2010, right. And what are the restrictions? This 2010 rules imposes severe restrictions. What are the restrictions, or you can say what are the activities which are prohibited in wetlands? First one is, reclamation of wetlands is prohibited. But unfortunately, 80 to 90% of the wetlands were reclaimed unauthorizedly, mostly with the support of politicians in several cities. Then second point is, disposal of hazardous substances. Sometimes biomedical waste is also dumped into wetlands, and this hazardous substances dumping is basically resulting in pollution, and the traces of cadmium, chromium in these wetlands are basically due to the dumping of hazardous waste. Then the third point is, discharge of untreated sewage. And it is unfortunate to say, even in metropolitan cities also, untreated sewage is let into the lakes, which is polluting the lakes. And then any construction of permanent nature is prohibited as per these rules, and solid waste dumping is prohibited. But these are not followed, these are not being implemented in true letter and spirit. That is unfortunate story. Then what are the reasons for failure? Finally, before concluding this topic, why we are not able to protect our wetlands, why incidents like Ulsur as well as Bengaluru are taking place quite often. First one is, lack of coordination among various departments. It requires a lot of coordination in municipal areas, and lack of coordination is one aspect, and these guidelines are violated normally across the country. This is unfortunate aspect. reclamation of wetlands and subsequent constructions resulted in disappearance of water bodies and untreated sewage is let into the lakes. Then commercial exploitation of lands in catchment areas, and when catchment areas are destroyed, then the natural water channels into lakes and rivers will be destroyed, and because of which the lakes and rivers will be left with more and more pollutants. Then natural waterways were lost. Probably some of the rivers have lost their origin. In Mumbai, in Bengaluru, Hyderabad, several rivers were lost. Then all the unwanted things are dumped in water bodies in cities. So these are the reasons for failure. What is the need of the hour? The need of the hour is stringent regulations with coordination is the need of the hour. So let us conclude this topic. Look at the second issue, upsetting a very fine balance. This is with regard to encroachment of Supreme Court into the fundamental rights. Supreme Court is supposed to protect the citizens against the excesses of the legislative wing. Please do not forget 3 archons. The guardian of the constitution or the guardian of fundamental rights is the judiciary, and in this article, or you can say the article is quite critical about judiciary's role with regard to suppressing fundamental rights. When legislature is passing certain laws which are in contravention to the fundamental rights, or you can say if they violate the fundamental rights, then the ultimate guardian is judiciary. But now what happened? Judiciary itself is encroaching into the fundamental rights of the citizens. The author cited 2-3 cases, and please do not forget, fundamental rights are forming part 3 of the constitution. They are from article 12 to 35. Article 12 defines what is a state. Article 13 says that no law should be contravenous to the fundamental rights, and then subsequently they are listed as right to equality, right to freedom, like that, and the last important aspect is right to constitutional right to the remedies. That is one important aspect. So from article 12 to 35 is part 3 of the constitution, that is fundamental rights. Now the author says judiciary is encroaching into the space of legislative and itself is putting so many restrictions on the freedom, right. So before going ahead, what is the mind of the constitution framers? Constitution framers in fact kept more faith on the citizens of the country, because universal adult franchise, universal voting rights were given from day 1 of the constitution. And please do not forget, at the time of independence, our literacy rate was hardly 15% or 18%. In spite of a low literacy rate, constitution framers have kept a lot of faith in the citizens of the country, and they have given this universal adult suffrage. And the constitution also guaranteed all the citizens fundamental rights, and which include fundamental right to freedom of speech and expression. This is very important. So the constitution protected citizens' rights through 2 layers of safeguards. One layer is legislatures have to make the laws, and subsequently the courts will be called upon to test constitutionality. If the Supreme Court, if the legislature like the parliament frames the laws which are against the fundamental rights of the citizens, then the second layer is there, that is the Supreme Court. Then that would be called upon to test the constitutionality. And now what is being happened? Leave the legislature aside. Now Supreme Court is encroaching into the fundamental rights. That is all about this article. So what is the present issue? As per the author, in recent times, Supreme Court has begun to redefine the role from the guardian of civil rights to a moral and political censor. The guardian of fundamental rights is Supreme Court, and now it is coming into the space of to becoming moral and political censor. And constitution framers never envisaged this, and it is the role that vests great power without any accompanying responsibility. When the Supreme Court is coming into the space of encroaching into fundamental rights, then who will protect the citizens? Because ultimately the Supreme Court, which is to guard the citizens against the excesses by the legislature. So, this is the main part of this article. Two instances are cited here. First instance is Bombay High Court found, I am talking about this Jolly LLB 2, Bombay High Court found certain scenes of the film as defaming the legal profession. Bombay High Court felt that certain scenes were defaming the legal profession. And please do not forget, there is already a statutorily established censor board. Statutorily established censor board is already there. Censor board has gone through the film and censor board certified it. What is the need for Bombay High Court to interfere into the picture? Then High Court set up an entirely fresh committee. How can High Court set up an entirely fresh committee when statutory body of censor board is there? Then High Court ordered 4 cuts to be made further in the film, as the court felt that they are defaming the legal profession. Producers subsequently moved the Supreme Court. Supreme Court refused to intervene until High Court passed the final orders, and producers, without further loss of time, finally bargained with Bombay High Court and reduced the number of cuts. And you see, in November 16, Supreme Court passed an interim order compelling all the cinema halls to play national anthem, and whereas in the instant case, Supreme Court was silent, with the Bombay High Court intention of parallel censorship mechanism. So, what is the need for parallel censorship mechanism? Basically, it will stifle further the freedom of speech and expression. So, questions are being raised with regard to legality as well as constitutionality in the above 2 issues. Look at the next issue. There was an act, 1994 Act, Preconception and Prenatal Diagnostic Techniques Act 1994. What is meant by prenatal? Prenatal means before the child is born, during the stage of pregnancy. During the stage of pregnancy, sex determination tests are banned as per the Act of 1994, and it prohibits advertisements with regard to prenatal sex determination. It prohibits advertisements. Supreme Court recently directed search engines such as Google. It directed search engines such as Google to constitute in-house committees to block access to such websites, and subsequently it passed a order to block search keywords in one stroke. The search keywords are also to be blocked. Is it not interfering into the freedom of expression? And then the Supreme Court order is making entirely the domain of internet off the limits for particular search. For particular search, it puts the domain of internet off the limits, and that is for everyone irrespective of the purpose, research purpose, it may be for research purpose, investigation purpose, or for the simple curiosity. When some search word is blocked, then is it not interfering into the altogether freedom of speech and expression? Then this is the process of the aspects pertaining to totalitarian society. So, the Supreme Court's order in this way is basically in the form of totalitarian society, where state assumes lot of powers, where citizens' rights are suppressed. One example is China. So, these type of actions are in the nature of becoming totalitarian society or totalitarian governance, right. So, here what are the final conclusions? In Jolly LLB2 and national anthem cases, courts have not even thought of whether what they are doing is within the legal framework. In the sex determination case, judicial orders were passed basically to make the internet off the limits for particular keywords. Then instead the legislatures making the laws, the courts have begun to make its own laws. When court is making own laws, basically limiting, restricting and suffocating the speech, then who will protect the people? Supreme Court is supposed to protect the people against the excesses of legislature, and in this case when Supreme Court itself is suppressing the speech, who will protect the citizens? That is the $1,000,000 question. And the transformation of the Supreme Court into Supreme Censor is unpleasant shock, and it is against the wishes of the framers of the constitution, right. So, this is quite important article. I hope you understood the essence of this article. Look at the next article, Speak in Our Own Voice. This is the article written by Suhasini Haidar, Diplomatic Affairs editor of the Hindu, and Speak in Our Own Voice. And there are 4 problems which are basically which resulted in strain between India-China relations. And these 4 instances, let us look at these 4. First one is, there is already boundary dispute between India and China, and 1962 war was fought on this issue, and China does not recognize the sovereignty of Arunachal Pradesh as integral part of India. This is one issue. Second issue is, especially with regard to South China Sea, United States of America and its allies like Japan, they want India to participate in joint patrols to confront China's naval ambitions. China is going quite aggressively in South China Sea, basically to confront China, India, in fact United States of America and its friendly countries like Japan, they want India to participate in these naval ambition, in these patrols, basically to control the naval ambitions of China. Let me repeat this. Basically to control China's naval ambitions in South China Sea, United States of America would like to take the help of Asian countries, and India is one of those countries. Then third point is Gwadar Port. Gwadar Port and Chinese investments in Pakistan. China is going for aggressive investment of $46 billion in Pakistan, and the irony is this passes through Pakistan occupied Kashmir. Then another contentious issue is India giving asylum to Dalai Lama. India gave asylum to Dalai Lama in 1959, and Dalai Lama was treated as a separatist leader in China. That is why the relations between India and China suffered for the past 40-50 years. So, these are the major contentious issues, and the article talks about America deliberately trying to further increase the strained relations between India and China. USA is trying to create further wedge between the relations between India and China, and it cited 4 instances. First instance is US ambassador to India before his resignation gave unusual dinner to one of the invitees was leader of the Tibetan leader in exile. He gave dinner, and one of the invitees was quite unusually leader of the Tibetan leader in exile. When people are talking about Dalai Lama or Tibetan people in exile, the first country to become infuriated is China. Then second point is Richard Verma visited Tawang in Arunachal Pradesh and Chinese foreign minister commented about third parties interference. There is nothing wrong in United States of America's ambassador to visit Tawang in Arunachal Pradesh, because Arunachal Pradesh is an integral part of India, but these 4 actions, if you say, they may be right, but as per the author they are diplomatically not correct. Diplomatically, if you see, they will further infuriate China. Look at the third one. US Consul General recently visited Arunachal and he referred Arunachal Pradesh as integral part of India. There is nothing wrong in this statement, but as per the author, what is the need for third party like America to voice this by visiting Arunachal Pradesh, as already the relations between India and China strained? Fourth one is, in April, this USCIRF commissioner attended a conference in Dharamshala. A conference in Dharamshala was attended by the America's official, and this conference in Dharamshala was included this Tibetans as well as Uyghurs. These Uyghurs are Turkish origin people. They are in Xinjiang province of China, and China is not happy with Uyghurs, and Uyghurs are treated, some of the Uyghurs are treated as separatists by China. And what is the need for US official to invite these dissidents, or otherwise you can say, what is the need for the USA official to participate in this conference by dissidents of China, which include Tibetans and Uyghurs? So, these 4 points, if you critically examine, they are with a nature of creating further wedge between India and China relations. Though some of these actions appear quite appropriate, but diplomatically speaking, it tantamount to third parties' comments in the internal affairs or bilateral relations of 2 countries. It is further infuriating China, probably United States of America want it. Now, we have to wait and see how Donald Trump will take further pivot to Asia plan, right? And last one, how to fend off bouncers. This is with regard to the appointment of Committee of Administrators. Committee of Administrators was appointed by the Supreme Court to govern BCCI and state committees. Not only that, IPL, all these things now will be governed by Committee of Administrators. It dismissed BCCI secretary as well as treasurer, and this Committee of Administrators was appointed Vinod Rai, then Ramchandra Guha, famous historian and cricket chronicler, and Diana Edulji, former test cricketer, and Vikram Limaye, MD and CEO of IDFC Limited. And instantly Vikram Limaye is going to become the new CEO of National Stock Exchange, please do not forget, and these 4 members are part of Committee of Administrators. And please do not forget, Justice R.M. Lotha committee gave recommendations with regard to the transparency in BCCI working. Supreme Court accepted most of the recommendations. These recommendations were accepted by the Supreme Court, but 2 recommendations were not accepted. They were left to central government. These 2 are legalization of betting and the issue of BCCI coming under RTI Act. These 2 were not accepted by the Supreme Court, and these recommendations were accepted. Now, to implement these recommendations, this Committee of Administrators was appointed by the Supreme Court, right? And now, main objectives of the Committee of Administrators is oversee the adoption and implementation of Lotha committee directives, not only by the BCCI, but also by the state associations. Second one is consolidating Indian cricket's standing with International Cricket Council and major decisions relating to IPL and BCCI's sponsorships. And finally, the most important aspect is introducing a governance structure that serves as benchmark how Indian cricket is to be governed, right. Then finally, what are the challenges? The challenges are to make state associations willing to accept the reforms is one of the major challenges. State associations, if they have to accept the recommendations, then some states have got 2-3 boards, some states have got 3 associations, and if you look at Gujarat, Baroda is there, Gujarat is there. If you look at Maharashtra, Maharashtra is there, Vidarbha is there, Bombay is there. So, now the committee of Lotha committee stated that there should be only one for each state, and now that is going to be the biggest challenge. Then media rights agreement, and IPL will have its new media rights agreement, and how the new committee of this administrators will look at this aspect. And COA, Committee of Administrators, has to deal with ICC's revised structure also, and at the same time IPL's governing council is to be reconstituted. What is the ultimate purpose? Ultimate purpose is to bring back the governance structures at BCCI level as well as state level with utmost transparency. Right friends, we discussed 4 important aspects today, and please do join for comprehensionability discussion at 12 o'clock. We are going to deliberate on banks merger with the State Bank of India. There we are going to deliberate some aspects with regard to banking structure, and please do join for other modules and capsules of learning space. And we are going to upload 3 parts of this union budget either today or tomorrow, and economic survey will follow, and as usual 3 capsules and why and how facts and figures will be there from 9th week without any interruption. And with this, let us conclude today's editorial discussion. Have a nice day. Thank you.